My academic colleagues, Dr. Giuseppe Mazziotti, who unfortunately cannot be here today, but was made the lead moves in organising this lecture, and also Dr. Angelica Phillips, who is the convener of the research group and has also put together today's lecture, as well as Catherine Finnegan in the law school, who's organised everything. It's particularly appropriate, I think, that we're here in the Science Gallery. The Science Gallery is dedicated to collaboration on the interface of science and art, and in a way that's what today's lecture is about. So I think it's a particularly appropriate location to have the lecture. The lecture, as you know, is of course going to be delivered by Professor Jane Ginsberg, who is the Morton L. Janklow Professor of Literary and Artistic Property Law in the University of Columbia. She's flown in from the USA today, this morning, to give this lecture, so we're hugely grateful to her for coming all this way. The title of the paper itself is an intriguing one. It's Intelligent Machines, Who or What Creates a Work of Authorship. I'm very much looking forward to it, so I'm not going to delay it anymore. Professor Ginsberg will talk for about 40 minutes, and then we'll have an open question and answer session. We will need to use microphones for that, so just bear with us on that, but apart from that, it'll be fairly informal give and take between you and Professor Ginsberg. So without further ado, I'd invite you to welcome Professor Ginsberg to Trinity College.
Thank you very much, Dean Doyle. And it's a great pleasure to be at Trinity College, Dublin. My previous visits have been purely as a tourist. My daughter has been here as a debater several times, but this is my first opportunity to be on the inside, and it's a great honor. I'm also delighted to be giving this talk in this venue with what I gather is a very mixed audience. In other words, not just law students, because this is a work in progress, and I'm still gathering a lot of facts, and many of the facts that I'm missing, I hope will be supplied by those of you who are in the science and technology fields, and I think it may become apparent where there are gaps in this discussion. So I'm looking forward to the Q&A that will follow the formal or semi-formal presentation. The topic of intelligent machines and authorship has become a very hot one lately. The question of whether the outputs of these machines are the subject matter of copyright or some kind of intellectual property right has moved from the academic law journals to such places as the European Parliament, which has been considering whether there ought to be some EU-wide legal regime for the outputs of intelligent machines. As those of you who are lawyers and law students probably know, the UK in 1988 was the first country to enact a law specifically addressing computer-generated works, and we'll talk about that a little later in the talk. Ireland in 2000 also added a provision on computer-generated works, and a number of other Commonwealth or common law countries have some provisions, but in no country has there been anything like a developed case law interpreting these provisions. There's only one case in the UK, and I'm not sure that it even really concerned a computer-generated work. So we're kind of in a lot of open territory when it comes to the positive law. This talk is about what the positive law might or should be with respect to computer-generated outputs. The concern is that there comes a point when human beings' relationship to the output is so attenuated that it's difficult to say that there's still a human author. In copyright law, we consider that the author is the person who both conceptualizes the work and executes it, or at least exercises control over its execution if third parties are actually building or creating the work in some concrete form. So amanuenses, the assistants of artists and so forth, but they're all supervised by the author, be it the writer or the artist and so forth. So the question for computer-generated works is, where do they fall on the spectrum of conception and control over the execution of a work? And this question did not begin with computers. In fact, the question of challenges to the authorship of works goes way back to photography. That was the one of the early instances in which the concern or the objection to protectability of a work was raised on the ground that the production was not the work of a human author. You probably recognize the figure in that picture. It's a local hero, I suppose. This is a photograph that was the subject of a lawsuit that was adjudicated by the Supreme Court in 1884 involving Napoleon Cerrone, who at the time was a very successful celebrity photographer who took a series of photographs of Oscar Wilde. And this photograph was copied, actually in the form of a lithograph, and Cerrone sued. He was able to plead the statute because Congress had recently amended the copyright laws to provide specifically for the protection of photographs. The objection, therefore, was that Congress might have desired to protect photographs, but Congress didn't actually have power to protect photographs because Congress can only legislate within the limits of the power that is given to it by the United States Constitution. And the Copyright Clause of the United States Constitution empowers Congress shall have power to promote the progress of science, meaning learning, by securing to authors for limited times the exclusive right to their writings. And it was argued that the photographs in general are not the writings of authors because they are the product of a machine. They are different from any other form of reproduction of an image because the image is first created by hand and then the mechanical means of reproduction do not actually create the image. But with a photograph, you don't have a photograph without a camera, so the camera is an integral part of the creation of the work. The Supreme Court rejected that argument on the ground that Cerrone exercised the determination of what the picture would look like. Curiously, he didn't even push the button on the camera. So with respect to the kind of mechanical aspect, that was not his contribution to the image. Rather, he did all the mise en scène. He dressed Oscar Wilde in that somewhat fanciful way and put him on top of a pile of Persian carpets with some potted plants in the background and had suggestive lighting at a particular angle. So all of the compositional elements of the photograph were conceived by the photographer and represented his original conception. So it's, even though the pushing of the button was done by an assistant, that did not take away from Cerrone's authorship of that particular image. So that is an important case in U.S. copyright law for recognizing that notwithstanding the intervention of a machine, if there is sufficient human conception and control over the output. It's still a writing of an author, or in today's statutory language, we would say an original work of authorship, and it is protectable by copyright. But the Oscar Wilde case was a relatively easy case because that photograph was so obviously artistic, with a capital A. It's actually fairly pretentious, and there's no question that the photographer was striving to be artistic in the photograph. One of the objections of the defendant was that a photograph merely represents reality. Oscar Wilde looks like that. But as all dressed up by Napoleon Cerrone, we have kind of an addition or an embroidering on reality. What do we do when the photograph looks like this? Right? You remember him fondly, I hope, wistfully perhaps. The photograph that you see on, I guess it's your right, is that right? Anyway, that one, right, was taken by a photojournalist at a news conference that Obama held during his first campaign for the presidency in 2008. And it was copied without authorization by an appropriation artist named Shepard Fairey to create the famous campaign poster for the first campaign. The Associated Press, who employed the photographer Manny Garcia, who created the photograph, said, we don't want to enjoin you from producing this poster, we just want to be paid. The photographer objected, brought a declaratory judgment action of non-infringement, and advanced 2 grounds. The case settled, so we don't have an answer. The second ground was fair use. It's the first ground that's of interest to this talk, that he didn't take any authorial contribution on the part of the photographer, because unlike the Oscar Wilde picture, the photographer simply seized a moment, but Obama looked that way without being instructed by the photographer to pose the way Oscar Wilde had been instructed to pose. And the photographer didn't create the background. It happened to have been a happy coincidence that Obama was sitting in front of the American flag. But according to the defendant in that case, there was really almost no authorial contribution. This really was freezing a moment in time, and any authorial contribution that there might have been wasn't taken by Shepard Fairey because he changed the contrast, he sort of Warholized the image. As I said, we don't have an answer from a court in that case, but it raises very interesting questions about what is the authorial value added in essentially photojournalism. Photojournalists will tell you that the art is indeed knowing when to seize the moment, and that in a sense, the message that Shepard Fairey was making explicit was already implicit in the way that the photographer took the picture of Obama in the first place. So maybe we still have sufficient authorial value added, notwithstanding the intervention of a machine, but it's rather more attenuated than in the Oscar Wilde case. Moving further away, literally, this is a satellite photo of lines in the Gobi Desert. And the company that owns the satellite has put a copyright notice on the photo, so they think that they have created a work of authorship. But this raises a lot of questions. After all, those lines are really there in the Gobi Desert. And the satellite is even further away from posing the subject. The satellite's just rotating. What is the authorial intervention in this instance? Well, one might say if there is somebody at the controls and as the satellite is passing over, the person at the control says, "This is exactly the shot I want." So presses the button. Well, that's kind of like the Obama picture. We've seized the scene that we want, and perhaps there's enough there, even though there's no posing, there's no costuming, not clear if there's really any framing of the picture. In the Obama case, you could say that the aspect ratio of Obama to the flag, which is very much part of the overall message of the picture, that is a contribution of the photographer, but it's harder to argue that with our lines in the Gobi Desert. But maybe just taking the picture, deciding at what moment you want to capture that image, that you still have enough authorial input. Now let me change the facts. Suppose that the satellite was programmed to take pictures indiscriminately every 30 seconds or every 10 seconds. So now there's nobody at the controls saying, "This is the picture I want, seize this image," right? The satellite just spits out all those photographs. Subsequent to that, a human being goes through the hundreds of images that the satellite has produced and says, "That's the one." Right? Well, does it matter? Does it change everything if the human being decided before the picture was taken that this is the image, as opposed to selects among randomly generated images the image that he or she thinks conveys the picture that is in the mind of the alleged creator? It's not at all clear, at least as a matter of positive legal doctrine, whether making that selection subsequent to the taking of the picture is sufficient, even though you would have the exact same result if you made the selection before. Should everything turn on whether a human being was at the controls at the moment the picture was taken, or made the selection after the picture was taken? Do we care about the human intervention at the time of the creation, or can we sort of attribute authorship post hoc? I don't have an answer to that, but as we'll see, the fluidity of the concept of where is the creative input by the putative author will come back to raise a lot of questions when we move from images where there is some human input to ones where we are less certain about the human input. Now, this, of course, is not simply a problem of machines. The problem of non-human creation is notorious. You've probably seen the so-called monkey selfie, right? And there's two different versions of this story, and the copyright consequences of the two different versions of the story could be radically different. The first version of the story, which is the one that got all the play, was that David Slater was in Indonesia and observing macaques, and one of them, Naruto, came along, stole the camera, and started to take pictures of himself, the so-called monkey selfie. Well, if that's true, what's David Slater's input? He supplied the camera, but otherwise everything was taken away from his control. So if there's a creator, in this view, it would be Naruto. But we actually now have case law in the United States that says that only a human being and not any other kind of primate can own a copyright. We have this ruling from the Northern District of California because an organization you may have heard of called PETA, People for the Ethical Treatment of Animals, brought a lawsuit claiming that Naruto was the author and copyright owner of the picture, and therefore any royalties that Slater had earned should be paid over to Naruto. Now, Naruto may take good pictures. We don't know that he has a bank account. But PETA claimed to be the next best friend of Naruto, and in that guise claimed the royalties. Well, you may not be surprised to learn that the district court held that copyright is limited to only a human being can be an author in the sense of the copyright law. The case went up to the Ninth Circuit. It's settled, so we don't have a ruling from an appeals court, but I think it's probably a pretty good interpretation of at least the U.S. copyright law that authorship means human authorship. Now, the other version of the story could have led to a different conclusion. Under version 2 of the story, Slater said that he had gone to the park in Indonesia and he had set up the camera. And he knew that the monkeys were curious, and so sooner or later, a monkey would come within the viewfinder of the camera, and the curious monkey would push the button. Now, under that view, it's not quite the Oscar Wilde photograph, but under that view, Slater has conceptualized the image and framed it, and there might be enough control. There's admittedly some random force. When is the monkey going to come along and push the button? But perhaps there's enough there on the part of the photographer to say that the fact that the monkey pushed the button doesn't make the monkey the author. The photographer is still the author. And Slater has told that story too, because I think he realized, possibly with the advice of counsel, that that was going to lead to a better outcome for him because we put the human authorship back in. This is a case involving other forces of nature. This is a garden, a sculpture made by a sculptor in the United States, Chapman Kelly, who works with natural materials, right? In this case, wildflowers. And he planted he prepared the soil in a park in Chicago, having studied the patterns of winds and the wildflowers that would come along at different seasons in order to create these changing color patterns from the wildflowers. The city of Chicago decided, for reasons unknown, to take Chapman Kelly's ovals, the sculpture consisted of 3 ovals, and turn them into rectangles. Chapman Kelly said this violated the integrity of his artistic creation. And the city of Chicago said the minuscule moral rights law in the United States that protects works of visual art still requires that the work be a work of authorship, and this is not a work of authorship because the author here is Mother Nature. It's not Chapman Kelly. He didn't control the process. It's entirely too random. The decision has been criticized a lot on the ground that the court didn't understand that it's possible to incorporate randomness within one's creation but still maintain a sufficient level of control in the execution of the conception, that there's still authorship. So there's not a dispute as to what the terms of the debate are, just rather on whether or not Chapman Kelly's relationship to the output of the winds was too attenuated for the garden to be protectable. The court contrasted Chapman Kelly with Jeff Koons, who created this sculpture in front of the Guggenheim in Bilbao, which is also all natural materials. It's all flowers. It's a mesh of a puppy, and then it's all filled in with flowers. But the court says this is different because Jeff Koons designated every single flower Right? His assistants actually did the planting, but in terms of specifying the overall work, that was all, nothing was left to chance. And that's the difference. You can work with natural materials, but these natural materials, in essence, are no different from any other sort of construction materials, totally controlled by the artist. Last example, before we get to the computer-aided examples, these modern non-representational sculptures by a conceptual artist named Agnieszka Courant are actually termite mounds. She feeds colored crystals to termites and then lets them go and excrete, right? And as they excrete, they make these abstract forms. And she's has been rather successful in exhibiting and selling those results. This may be the end of the line on the copyright side, because here she's got an idea, right? But copyright doesn't protect just an idea. I said at the beginning, it's the conceptualization and the execution. Right? And she in no way controls the execution of of termite excrement. So that's, it's not even Chapman Kelly who has carefully studied the pattern of the winds and the wildflower seeds, et cetera. She's just let those termites go and do their thing. Right? So at this point, we may have some terrific conceptual art, but copyright doesn't protect the concept, right? You have to have the work, and it's not clear in this instance whether or not we have sufficient human intervention in the actual output. Right? Now, with those principles in mind, we turn to the computer examples, because whatever we come up with for computers as a matter of copyright law, I think that the principles ought to be the same. So the principles that we have derived from these earlier examples involving attenuated human input should help guide us when we consider what to do with computer-assisted or computer-generated works. Now, one can think of these on a continuum. We probably wouldn't say that works created using Microsoft Word are computer-generated works, or as for computer-assisted, they are in a sense computer-assisted, but I don't think anybody would claim that the Microsoft company has any kind of authorship or much less ownership interest in anything that was created using Microsoft Word. So that's kind of one end of the spectrum. But at the other end, we may have works that truly are computer generated. So let's explore what that might mean. Here, closer to the Microsoft Word end, this is Photoshop. Right? And Photoshop can remove things that you don't want in the picture and fill in the background. It can repair damaged pictures. And it relies on a program and information that will help it fill in that background. But again, I don't think that anybody would claim that that Photoshop is the author of the result. It's a tool that assists people in correcting the images, but we're still pretty securely on the people side of this continuum. Now it gets more complicated. This is a program created by Google which creates harmonies to a melody. So a human inputs the melody, and then the program generates the harmony, and it's not just thirds and fifths in response to the melodic line. It's actually more complicated. So can we have the audio? Okay, thank you. So here we have a human being who inputs the melodic line, but that does not control the harmony. That's determined by the Google program. So this is one where it's assuming that it is true that the choice of melody does not determine the harmony, that we are moving away from our paradigm of human authorship. The next example is even more challenging. This is a program that was developed by people at Cambridge University. It's called JukeDeck. And whereas in the previous example, there is a human being who creates the melody, at least. In this case, the user does not create a melody. The user simply picks genre, instrumentation, and sort of mood, and how long the resulting piece should be. So can we have this one? No, I'm sorry. Yeah, the audio on this one. Okay, thank you. Okay. That may be too banal to, even if created by a human being, it would be maybe borderline on originality. But if the output, if created by a human being, would be sufficiently creative to support a copyright, our problem is that all the human being has done is simply select certain parameters, and then everything else is supplied by the program. And the less the putative human author contributes, the harder it becomes to say that the output is a work of human authorship. Let's do the next one. Oh, I'm sorry, that one I do. Okay, all right, back to Oscar Wilde. So that you've got the original photograph, and then you have Oscar Wilde meets Van Gogh's The Starry Night. This is another Google program that allows you to sort of create a mashup. So you can take one image and then filter it through another image. And again, we've got some doubt about how to treat that output, because simply the idea of doing Oscar Wilde meets Van Gogh is not going to be protectable. And if there is not any further intervention on the part of the person with the idea to do The Starry Night over Oscar Wilde, it's not at all clear that we have any authorial value added by the human being. In contrast to, you may have seen this is the so-called Next Rembrandt, which was created by a team of art historians and technologists in Holland. And they fed into a database every portrait that Rembrandt ever made, and then they selected criteria, sort of like JukeDeck, that they wanted a man who was about 35 with a black hat and a goatee and the ruffled collar, but their participation didn't stop there. This is a mashup as well, but this is a mashup where the team continued to intervene in the development of the image. So that a computer helped to made this technically possible. Indeed, this is not simply a digital image. It's actually a canvas which has been 3D printed to replicate the actual thickness of the brushstrokes in Rembrandt's works. So it might be vastly aided to have all the technology that generates this, but there really was human supervision throughout. So the next Rembrandt probably does not pose significant copyright problems in terms of assessing whether or not this actually is a work of authorship in traditional copyright terms. This one is more problematic. This is the robotic arm and program known as Paul creates portraits in the style of the programmer, who is an artist who didn't think he could make it in the art market, so he went into being a computer program, and then he put his two passions together. So the program has been instructed to draw the features of the subject of the portrait as if it had been drawn by the artist who programmed the computer. This is not, I think, in strict terms, this would not be considered really the work of an intelligent machine in the sense that there's no machine learning. The machine executes the instructions that have been provided by its programmer. It doesn't come out with something that the programmer didn't anticipate. For a truly computer-generated work, the program interacts with the database in such a way that it accumulates learning and starts to do things on its own. Paul is not there yet. Finally, our last example, and it's an audio example. This is performed by a human being, but the score was written by Iamus, who is a computer program and has generated this composition. Okay, thank you. Now, this one may well be a truly self-taught example, that the computer is going beyond the information that it has been fed to create its own new combinations of notes. Now, you may be able to see on the top of the score, it says, "In Memoriam Alan Turing." The Turing test posits that if you can't tell the difference, that we get to the point where you can't tell the difference between a human-created output and a machine-created output. And the question for copyright law is, if we get to that point where it is truly machine generated, not simply computer assisted, but generated, and you can't tell the difference between a human output and the machine output, what should we do about that? There are some authors or legal commentators who have said, if you can't tell the difference, well, then just treat it as if it were a human-created work. But that's problematic from the copyright point of view, because copyright even in common law countries, is still very much a humanist concept. It is based on the idea of human creativity, that there are really two pillars of copyright law. One is the natural rights theory. You created, it's yours, it's the fruits of your intellectual labor give rise to a property right. Some variation on that theme is that the work bears the stamp of the personality of its creator. You'll hear that a lot on the continent. And for all those reasons, the work is protectable because it is the fruit of intellectual labor. That's one justification for copyright. The other justification for copyright is the incentive theory, expressed, for example, in the very first copyright law, the Statute of Anne of 1710, an act for the encouragement of learned men to write useful books. We provide exclusive rights, a property right, because we think that will provide an incentive to get people to create works, and it's good for society as a whole if those works get created, and we're concerned that if we don't provide those exclusive rights, works won't get created because unscrupulous competitors will free ride and destroy the commercial value or return to the creator of the work. So those are the two basic pillars of copyright law. And the author part of it is very present in the Berne Convention, the leading international copyright treaty, which protects intellectual creations, and in the European Union, where the standard for originality is that the work must be the author's own intellectual creation. So all of that posits a human being, which makes it difficult to have copyright protection for these non-human outputs. But that doesn't mean that these outputs necessarily don't get any protection, because we've got that other pillar, the other justification, which is the incentive theory. Maybe we need some kind of protection for these outputs if we want to have the outputs produced. I think that's what underlay the UK 1988 law. But I also think that this premise needs to be questioned. In traditional copyright law, we generally don't ask, was copyright an incentive to the creation of this work, right? Would the author have not created the work if the author didn't have exclusive rights? Because there are plenty of, well, I don't know how many, but there's the poet who burns with inner fire and absolutely has to create. That class may be not as large as sometimes is thought, because poets need to eat. But then there's academics, right? Publish or perish. We have good day jobs, right? And we may not really care that much about the copyright. Copyright may not be a motivation to create the work. On the other hand, a lot of academics are actually very possessive of their works, not because of the non-existent financial return, but because you created, it's yours. And you don't want people leaving your name off of it, or you don't want people changing the work. So all of that kind of moral rights or human dimension very much underpins copyright, even when the incentive is lacking. But if you take the human out of it, then the only reason for protecting these outputs is incentive. And there, I would say, and this is the fact-gathering part, before we pass any more laws about computer-generated works, we need to find out more about whether those incentives are actually needed. remember that we're only talking about the output. There may well be lots of incentives on the input, that is, the database, which may well be the subject of copyright protection. And in the European Union, there's a special sui generis database right. The computer program, which may be protected by copyright, conceivably by patent, the machinery, conceivably protected by patent. So the inputs necessary to the outputs might already be the object of various forms of intellectual property. So do we actually need protection for the output? And who needs the protection for the output? And those are fact questions that surprisingly haven't really been explored. That's the work in progress part of my inquiry, trying to find out more about what kinds of outputs are we talking about, what kinds of incentives, and who needs those incentives. Because it's not clear, to conclude, that the laws that we have now in the UK and in Ireland actually are providing an incentive to the right party. The UK law states, in the case of a literary, dramatic, musical, or artistic work which is computer generated, the author shall be taken to be the person by whom the arrangements necessary for the creation of the work are undertaken. Well, who is that? It's not clear who is the person by whom the arrangements necessary for the creation of the work are undertaken. Are those the people sort of upstream from the output? Is it the person who pushes the button to create the output? Is it the person who pays for the creation of the output? We don't have any case law construing those questions. So until we can understand, first of all, whether there is such a thing as a computer-generated work defined in the UK law as generated by a computer in circumstances such that there is no human author of the work. Right? So a number of the examples that I showed you, there was a human author, or maybe co-author, but there is human participation. But somewhere along the line, perhaps today and more likely tomorrow, there will be works that fit that description. But we don't know what it means to make the arrangements necessary for the creation of the work. And if we don't know who that is, it's very hard to ascertain whether that person needs an incentive to be making those arrangements for the creation of the work. So I leave you with a lot of open questions, suggesting that such laws as we have may not actually be responsive because we don't necessarily yet have a sufficient grasp on the nature of the problem. And so I'm hoping that in the Q&A, which will now begin, those of you who are lawyers, and particularly those of you who are technologists, can help think our way through to some answers to those questions. Thank you very much.
I think this will work. So first, thanks for a really wonderful talk that started off with very eye-catching examples and has brought us on to some really profound questions. That's great. Just going to open it up to the floor. If you put up your hand, we'll pass you a microphone. You might just introduce yourself and keep your question or point relatively brief. And I think you're a good crowd, so this will go well. I'm confident.
Thanks a lot for that talk. I really enjoyed it. My name is Robert Elliott. I'm no one of consequence really in the context. In terms of incentive, it seems to me that when you've got pieces like Colossus, they serve more as a disincentive, or could conceivably serve as more a disincentive to compose, in as much as once you have the software, you are essentially able to churn out an infinite number of unique original pieces at will. And this is the same true for painting, for whatever. And there's less incentive then for humans to get involved because basically their work is going to be swamped completely. So, like I say, that seems to me to be a disincentive rather than an incentive for creation.
Okay. Very interesting observation. And I think the concern or the critique really turns on what works are being or can be produced in a truly computer-generated fashion as opposed to computer-assisted. And right now, we may have some examples of music of this type, and then the sort of generic jukebox, juke deck music, which might suggest that the people who make what we in the United States derisively call elevator music, right? Background music services, could dispense with human composers if really all you want is sort of anodyne audio ambience and rely on juke deck or something like that to spit out music that nobody's really going to listen to anyway. And it may also be that at the lower levels of literary works, it is already the case that there are programs that can write news reports and sports reports and corporate reports, and it may be that that sort of perhaps some of the rank and file of authors could find their livelihoods jeopardized. At the moment, the machine doesn't do so well at the higher orders of creation. I don't know how many of you are familiar with the new Harry Potter chapter that was computer generated, and I gather that it was not a huge success. Right? That it may be that the human imagination has too many moving parts, at least in some creative domains, that it's not a threat yet. Right? But I think it's a fair question whether the extent to which human authors might be displaced by machine authors, at which point I take it the implication of your comment is if we want to keep human authors employed, we should not have protection for machine-generated outputs, because that would just enhance the competition from machines. You would still have the problem that even if the output isn't protected, at least you're not paying the authors, the human authors. So, but that also goes to incentives, right? Do we need are the cost savings somewhere else sufficient to provide an incentive to create these works? Whether or not we want these works to be created, which is essentially your question, is another question, but it may also be too late to pull that one back.
Hi there, Theo Donnelly. To what extent, if at all, do you see there being any benefit to allowing copyright status to works which are created by artificial intelligence in circumstances where we maybe accept that they don't require any incentive to create the work? What benefit do you see at all in giving them authorship or giving any participant in their creation authorship, whether it's the person who created the algorithm or whatever? Because surely then the knock-on consequence is that those who might iterate on those works are hampered in so doing because of the authorship.
Mm-hmm. If you can't make the case on the incentive side, I don't think that having a form of intellectual property protection is justified. Because I can't justify it on the human ground. I'm generally not a big fan of requiring demonstration of incentives when it comes to human-authored works, but if if the human author truly vanishes, then the only justification is an incentive justification. And if that case isn't made, I don't see any benefit to providing somebody, and we're not even clear who, gets the monopoly rents. There was a question in the back.
Hi, my name is Owen O'Dell. I'm a lecturer here in Trinity. I want to make two quick comments and ask a question. The first comment is you were dismissive of Microsoft claiming copyright in everything written in Microsoft Word. I think that if Bill Gates could have made that claim in 1984, he would have done, but he didn't, so he didn't. The more serious observation relates to your example of the Gobi Desert, where you had the satellite taking the photographs on a pre-programmed order, and then somebody makes a choice afterwards, and you said that making of that choice probably doesn't trigger copyright protection. I agree, but I think that there are two cases that you need to consider in coming to that conclusion. One is the photographer who sets the camera to take 100 shots in a very short period of time because it's a sporting event and something's happening very quickly, and then choosing the one of that 100 that particularly captures the essence of the sporting event, the goal being scored or the touchdown or whatever. That is a pre-program subsequent choice, but the photographer is going to claim, and we are probably going to say simply as a matter of our instincts that the photographer is right to claim that he or she has a copyright there. Another example that is pretty common is video, where the TV company pauses the video, creates a still, and then claims copyright in the still because something happened while they were photographing the sporting event again. So that there are examples of pre-program, the machine does all the work, you make a subsequent choice, but we still think that there is something within our copyright instincts that is copyrightable. I agree that the Gobi Desert example is not. I agree that Naruto is not. But I think that the photographer who takes the photograph of the sporting event will have an argument with you. The third point, okay, labor desert and incentive. Europe, unfortunately, is beginning to take the view that copyright or related protections should adhere simply by virtue of investment. The reason why we have the sui generis database protection is because Europe was convinced by big American companies that their investment in their databases should be protected, and copyright didn't, so let's give us something else. They're now being convinced by the German news companies that the investment in news should create an adjacent or neighborhood right for news. So even though there isn't a good theoretical justification for copyright as business model, nevertheless, that is becoming the argument that lobbyists are successfully bringing to Washington, to Brussels, to Dublin. And I can see how if a big computer firm, a big AI company, generates something, spends a lot of money in the investment, they will persuade the politicians that there ought to be a protection in the output as well, even if it isn't a legitimate or justifiable one.
Okay. I don't think we're in disagreement about the desirability of demonstrating a need for the incentive, but a couple of things on the last comment. It's precisely because a lot of commercially valuable databases are not original works, or not the author's own intellectual creation, that the EU created this sui generis right, which is much narrower than copyright. It's a shorter duration, a narrower scope of protection. And so I suppose I should have made clear that if we're going to have some kind of special IP right for the outputs, that doesn't mean that it should look like copyright. Right? The UK law has a shorter duration. It's 50 years from the making. Here in Ireland, it's 70 years from the first lawful this making available of the work, arguably too much like copyright. In the UK law also has no moral rights, which, yeah, but moral rights, that's the essence of humanist copyright, no human, no moral rights. I suppose it remains to be seen how the scope of protection works out. So we've already got kind of it's already a bit of a neighboring right. But along with the premise that we ought to see what incentives are needed and who needs the incentives, we also need to see, when I say what incentives are needed, the fact that an incentive may be needed, if proved, doesn't mean that 70 years from publication is a necessary incentive. It doesn't mean that the full scope of adaptation derivative work rights is needed. So any incentive ought to be tailored to the facts that we don't yet have. On the question of authorial intervention before or after, I still think that the shutter speed, the photographer is still there taking the picture, so has intervened in every one of those frames, even if the photographer determines of those frames, this is the one I want. But that would be true even without a fast shutter speed, that photographers take lots and lots of pictures, but the one they choose to exploit is only one of many. In the U.S., we do have a kind of a weird case that may or may not get one part way towards the Gobi Desert hypothetical, which is one of our famous judges on the Second Circuit said in dictum that an author might create something inadvertently, that the author's poor eyesight might cause the picture to look different than intended, or a clap of thunder might cause the artist's hand to shake, thereby drawing lines that the artist hadn't intended to do. But if the author adopts those changes, so I didn't mean to create this, but I kind of like it, so I'll say it's mine, that by authorship by adoption. So can you take that and apply it to the Gobi Desert hypothetical, where it's I have adopted this image that I didn't take? Would that get you there? I think it's probably a stretch, because even with the unintentional authorship by adoption, there still was simultaneous creativity, even if inadvertent, on the part of the author. Whereas we're positing that in the satellite photos, it's too automated. Yes, you can kind of dress up the facts to say, well, they decided to take the picture every 10 seconds instead of every 2 minutes. You could try to dress it up, but I think that it's sort of the security camera problem, right? You have a security camera monitoring the automatic cash machine. I think most people would probably say that it's even the setting up of the camera might not be a sufficient act of authorship, because the setup is determined by the need to either focus very closely on the ATM, or the need to have the broadest image possible in order to see who else is coming along. But the constraints that don't have anything to do with creating works are dictating what might otherwise be considered authorial choices. So there are definitely some borderline works that are not created by computers, but which pose the same kind of problem. I saw a hand over there. Yep.
Yeah, and Owen actually kind of has dealt in his 3 questions at quite a number of the points I was going to raise. Deirdre Kilroy, I'm a head of IP in Matheson, which is a law firm here in Dublin. Just in terms of some of the struggles that you have sometimes when you're managing intellectual property rights through contracts, and you're giving assurances, and you're looking at the quality of rights that are coming through. I had something recently where we had a bundle of rights transferring, and we had the usual warranties around authorship and originality, because what was travelling through the contract was a bundle of, I would have said on first impression, oh, this is all copyright flowing through. But we had a challenging client who had, challenging in a good way, intellectually challenging, and kind of questioned what they had in their bundle, and it included some machine learning, AI, and certainly selections that had been taken out. So it's that quality of human intervention, and we got into a very kind of involved conversation around, you know, the selection process, the parallels with collages, for example, and this choice and selection, and what quality of threshold would bring it into the copyright arena. So it was a real world kind of struggle. And we solved it by giving the other side a warranty that didn't refer to authorship, which they seemed to settle upon, which was fine. But in terms of that test of human intervention, because it is an interesting question when law is always traveling behind innovation, and you're always trying to retrofit things that were never thought of at the time and place them in the context of a law that doesn't really deal with them properly. Would you see, if there was a sui generis approach to this, there being a test for human intervention of some description posited within the legal framework that you think would be kind of a justifiable way of modelling this type of arrangement?
It would be great if there were something that were kind of mathematically precise. And the point at which the human control over the output ceases to be sufficient is very difficult to establish, and probably very fact dependent. So it's kind of like another classic in copyright law, the idea expression distinction. Right? Copyright doesn't protect an idea, it protects the expression of an idea, but how do you know which is which? Right? So similarly here, if we're saying that a work of authorship requires that there be a sufficient level of authorial input, well, what is that sufficient level? At what point does the do forces, whether they're mechanical or natural, random, et cetera, take away from the author's ability to determine the output, recognizing that having some random elements does not defeat the authorship. Indeed, it can be part of the author's plan for the work to incorporate randomness. The court in the Wildflower case recognized that Jackson Pollock's splatter paintings are works of authorship, even though Jackson Pollock did not necessarily foresee how the trajectory of the paint would produce the splatters on the canvas. So he didn't totally control every aspect of it, but he controlled enough of it without the court saying, trying to come up with a percentage of what was random and what was controlled. So I'm giving a long-winded non-answer to your question. I mean, I can give you the terms of debate, right? But I do think that it can be very fact dependent to ascertain when the human participation becomes too attenuated, or the human participation is essentially limited to a command. Right? For example, if Julius II says to Michelangelo, "Paint me a ceiling," right? That does not make Julius II the author of the Sistine ceiling. Right? And that's just Michelangelo. But if Michelangelo and Julius II collaborated in deciding exactly which Old Testament scenes would be depicted and what the iconographic program of the Sistine ceiling was, then perhaps even though Michelangelo did all the execution and all the painting, the overall plotting out of the content of the Sistine ceiling, you could posit that it would be a collaborative work, and that could make Julius II a co-author with Michelangelo. So there again, no machines, but still raises the question. We have many tortured cases in the United States about co-authorship. When is somebody who either commissions a work and just says, I want this, that doesn't make you a co-author, but what if adds some suggestions? At what point did the suggestions accumulate enough to make you a co-author? These cases tend to arise not in the exalted example of the Sistine ceiling, but in a rather sort of humdrum case of architectural plans for everyday residences, right? Where the client hires the architect to build the dream house, and the client gives not only some general instructions but also some a lot of detail about where the closet should go in, this, that, and the other. Does that suddenly make the client the author or the co-author of the architectural plans? And then when the relationship goes south, who owns what? Now you're going to tell me absolutely correctly you take care of this by contract ahead of time, but all too often in human relations, we should have done this, we should have put this in the contract, comes up after the relationship has deteriorated.
So I think we have 3 more questions along the back. Maybe if we take the 3 in a row, go over to you, and that'll allow us to wrap up by around 7:30. So,
hi, just wondering, generally speaking, say for kind of England, copyright kind of can be attributed to where kind of skilled labour and judgment has been, but say on the continent, there'd be a fair amount of having to show a personality through work to gain copyright. Do you think then, if you were to see kind of potential for an EU kind of legislation to kind of give kind of what England has now to the continent, do you think that would be kind of compatible? Or do you think it just wouldn't work? Because if you've got something that's kind of developed by an AI that's kind of one step removed from the author, how would you show kind of personality within that work?
Well, I think that's a variation on the theme. Do you still have a human author? I mean, if you still have a human author, then the English legislation doesn't apply. It only applies when you can't find a human author. As for whether the English legislation is consistent with EU norms, the English law dates from 1988, which is before the European Court of Justice, before any of the directives that articulated the author's own intellectual work, author's own intellectual creation. The first directive to come up with that standard is 1991, right? So the UK law came first, and then we got some more directives applying that standard, and then the European Court of Justice has generalized that as the standard for originality in the EU. So now we have a disconnect between the English law and the Irish law and the European norm, and this at some point might come to a head. I don't think that if it's truly a computer-generated work, I don't think that it fits within the EU definition of what is a work of authorship that's protectable by copyright. And then that doesn't preclude protecting it under some other name and some other regime, but it's not going to be copyright protection. And significantly, that also means that it's not going to be entitled to international protection. because it will fall outside the treaty norms, which also assume human authorship. So England, Britain, and Ireland can, as a matter of their domestic law, protect these works, but that doesn't mean that those works will be protected anywhere else, absent there's a special treaty on these works or bilaterals or something, but these works fall out of the international copyright regime.
Hi, the name is Ed, and my fields are technology and music, which is why I'm going to use a music example. I'm interested in that linkage that you introduced very early on in the speech between the authorship or the creativity or that piece that you said can't be guaranteed in its own right, but there's a linkage that appears to be there with its production or realization. Now, to use, I say most people believe technology is almost creating music at this stage, but it's not. There's still an author, and indeed if you take a very early classical example where aged musicians may dictate the thoughts in their head to a musician to create it. Now, it sounds a derogatory term, but that the second person is largely a tool in that, unless for some reason they had a contribution, and surely that concept carries on as we go towards AI, etc. But it didn't appear to, and that's one thing I'm not really picking up on the legal aspect, which I have no legal background. Where's that linkage being made?
Okay, so I think that if we're simply talking about the computer as a, quote, tool, that's not going to pose particular challenges. We're in our traditional copyright concepts that have that indeed have concluded that if we go back to Michelangelo, I think he actually did the entire Sistine ceiling on his own, right? But if he had assistants, right, then and the assistants were strictly following instructions, right, then the only author would be Michelangelo. It gets complicated if the assistants start sort of going off on their own creativity, and there's a whole cottage industry of, say, identifying which angel in a Verrocchio painting was actually painted by Leonardo, right? Because he didn't strictly follow instructions. But assuming that we're really not giving any agency to the assistant, it shouldn't matter whether the assistant is a person or a machine. Where it gets harder is if it is true, or if it will be true, that the computer teaches itself through the iterative process of consulting the database. The bigger the database, the more the computer has to work with, that at some point the human contribution is paint me a ceiling, right? And then the computer actually does the rest, or compose me a sonata, and the computer does the rest. But that's based on the factual premise that the so-called neural networks and machine learning will get to a point where the computer effectively has agency.
Hi, Jane. Thanks for the talk. That was great. My name is Martin. I'm a music researcher in Trinity, and I'm actually researching the fiscal and ethical implications of AI in music. Curious sidebar to this, I'm thinking about Francois Vico, who's in the University of Malaga. The issue of music-generated copyright, the other side to it is that a lot of the people who are making the AI systems are not interested in having copyright. So, for instance, the variation of the IMS computer Melonomics produces huge amounts of volumes of MIDI files and audio files for the whole purpose, and Vico, as I said, the last thing he's interested in is copyright. Any thoughts about how that's going to impact? And there are other examples that I'm sure you know of. So they're not seeking how to create the...
Right, and I think for the pure technology slash music, and this is true for there are artworks that would fit in this category as well, that the question of copyright ownership is completely irrelevant. But if you think about potential commercial applications, right, then it's not irrelevant. But that's why I was raising the question, what are the commercial applications and who has the interest in getting what protected?
But they're using Creative Commons licenses. They're using Creative Commons licenses.
Right, but and Creative Commons doesn't pay, right?
Exactly.
That's great. But I don't know, I rather doubt that all of this activity will remain confined to the Creative Commons bubble, right? That there will be commercial applications. And at that point, the norms of the free software world, et cetera, that's their part of the creative universe, but it's not doesn't account for all outputs. So it may be that as to the commercial applications, we still don't need a copyright-like incentive, but that's where the problems are going to arise. Right? The question you pointed out, you've got these lobbies who are coming in and demanding publishers' neighboring rights and all these sort of fringe things because they have a business model that is in big trouble. Right? So where we're going to see it is people are going to come along and say, I have a business model and I can't get it off the ground because I can't protect the outputs. Right? Now that should be questioned, but I think that is the situation in which we're going to see the pressure for having a copyright-like regime.
Can I just thank everybody for your questions, but can we conclude by thanking Professor Ginsberg again for a wonderful lecture?
Thank you.